are going to start with our typical Zoom housekeeping tips. This is, we ask that people stay muted to prevent background noise and make it easier for everyone to hear. Your mute and unmute and start and stop video buttons are probably at the bottom of your screen. I'm sure we've dealt with enough virtual meetings that I don't need to go any further. So, as we say every week, and it still comes up fairly often, this is not legal advice. We are trying to give general information that is applicable to almost any community in our industry. We ask that if someone tells you condo law says X or Valerie or Ken said Y, if it comes from any of our blog posts, the Q&A, if someone sends you an excerpt or a link to a Q&A and says condo law says this and you're not doing it, ignore it. Unless you have specific advice from your association attorney regarding your community, it's just general information and may not be completely applicable to you and your situation. So in the past few weeks, we've been doing short primers regarding changes coming from this last legislative session. Last week was a great one on the changes regarding collections and delinquency notices. So if you have any questions, please feel free to go back to prior Q&As. We have all of our Q&As recorded on YouTube starting from, I believe it was April of 2020. So there's a wealth of information there, and it may take some time to wade through, but if you have questions, please feel free to check our prior YouTube channel. If you have specific topics that you'd like to have covered in a primer, please feel free to email info@condolaw.net with your suggestion. If we can make it work, we probably will. So I know this is coming up fairly far away, but it is still coming up. CA Day, which is the big community trade show for common interest communities in Washington State, is held in October. And for the educational content, they're asking for submissions to be done fairly soon. So if you have any suggestions for something that you'd like to see covered at CA Day, please feel free to email us at info@condolaw.net and we will take your submission into consideration. So one last thing before we get started into our questions for today, we're going to skip the little primer because we have enough questions to cover. Please note that there are 3 dates that are applicable for the changes coming in WUCIOA. So for WUCIOA communities and several provisions regarding the collections and delinquencies, those come into effect in July. So if you're a WUCIOA community, you need to pay attention to the changes that come into effect in July. There are several provisions that become binding on all communities regarding meetings and voting that comes into effect on January 1st of 2026. And then WUCIOA for all is effective, and all the common interest ownership statutes except for 6490 go away starting January 1st, 2028. So please keep these dates in mind when you are looking at the statutes. Please double check with your association attorney if you have any questions on which statutes are applicable to you now and when other statutes come into effect. There were a lot of changes made to the small community exemptions. So if you are a WUCIOA community now and had a small community exemption, take a look and see if that's still applicable, because it may not be. Ken, did you have anything to add?
Well, actually, it may be that the exemption encompasses more communities now, because they changed it from communities with 12 or fewer to communities with under 50 units. that have annual dues of less than $1,000 now instead of annual dues of $325. So the building community was successful in getting broader exclusions for plat development in the legislative session. But then the legislature made it clear that many more of the WUCIOA provisions apply to the excluded communities. So it used to be there was less than a dozen, and now there's 2 or 3 dozen that apply, mostly related to the protection of owners and the rights of owners to be involved in the decision-making processes. So it's becoming more confusing instead of less confusing as we move toward WUCIOA for all.
Okay, so moving on to our first question. Can you help explain what WUCIOA says about alternative dispute resolution? I believe it's addressed under RCW 6490-685. As a layperson, the intent of this RCW isn't entirely clear. Could you also give an example of what an association would do with this information in terms of adding ADR language to policy or however it was intended to be understood? So the section that you cite, 6490, 685, merely allows any party, which is the owner, the declarant, the association, subject to 6490, the ability to sue to enforce a right that is granted under the statute of the governing documents. It doesn't require ADR. So the part about alternative dispute resolution, merely states that if the parties are interested, they can attempt to resolve the issues outside of court with either mediation or binding or non-binding arbitration. Please note that this is applicable now as well. If you are not a WUCIOA community, if you have an owner who is disputing something with the association and agrees, you can do mediation no matter what, if both parties agree. If both parties agree, you can also do binding or non-binding arbitration. It's just, unless it's required in your governing documents, you can't require an owner to do it. So mediation is just a meeting of the parties with a neutral person there who's trained in resolving disputes. WSCAI, the Washington State chapter of CAI, Community Associations Institute, has a mediation program. So take a look at wscai.org if you're interested in more information about that program. In a nutshell, the mediator's goal is to bring the parties to a mutually agreed upon resolution. When it's successful, it works fantastically because both parties have input and they both agree that this is the resolution to this particular issue. Arbitration is similar to mediation, that it's not in court. The proceeding is before an arbitrator. The arbitrator listens to both sides and renders a resolution like a judge. In some cases, the decision of the arbitrator could be binding, which means the decision is like a court ruling, binding legally on both parties. Some governing documents require that disputes are resolved through alternative dispute resolution, which is mediation and binding arbitration. But in order to require it, it must be in your governing documents. Otherwise, as long as both parties agree, you can do that. Arbitration is generally faster and less expensive than court, but both parties have to agree that that's how the dispute is going to be resolved unless it's required in your governing documents. Ken, did you have anything to add to that?
Well, I will add, I was just looking at the statute. Under the powers of the association, the association does have the power to require alternate dispute resolution before a judicial proceeding. And so it's certainly possible that a community could adopt provisions that require ADR of some sort, whether it's mediation or arbitration, but it doesn't take away the ability of the parties to end up in court anyway. So that's all I've got. Question 2. The board is dealing with reconstruction of units following water line breaks. This involves a lot of coordination with contractors and decisions to be made sometimes daily. How can a board continue to move forward timely when decisions can no longer be made via email and meetings require 14 days advance notice? Or what can a board legally do without announcing a meeting first? So there's a couple different things that would help answer this question. One is there's a section of WUCIOA now, which will apply to all communities starting in January, which is section 502, and it deals with emergencies. And it defines what an emergency is. And then it's basically says that the board can meet without any notice to owners to deal with the emergency. You can have less than a quorum of the board to make decisions. You can provide any kind of reasonable notice to owners, but it is intended to deal with things like fires, earthquakes, and I assume if the water leak fits the definition of an emergency, it would deal with that as well. The second thing is that the statute is being amended, meaning WUCIOA, this year, which will be effective in July, but will apply to every community in January, so that if there are circumstances where 14 days notice is not practical, you can get by with 7 days notice as long as you make an effort and email that notice to your members. I'm not exactly sure what the purpose of this was, other than an attempt by the legislature to deal with all of the complaints, which are just like this question of owners saying it's not possible to comply with these notice requirements for meetings. So it may be that the decisions you need to make would fall under that 7-day guideline instead of the 14-day guideline. The other thing is that the answer to this question really depends a lot on what you define as a ministerial act. If the board has already made a decision to conduct repairs, then the methods and the day-to-day decisions about where a pipe runs, or whether it's plastic or copper, or do you do a change order, those may end up becoming ministerial acts, which could still be done by email, because the primary decision was already made by the board in accordance with its requirements. And the other thing that you might be able to do would be to have the board delegate certain kinds of decisions to a manager or a committee or a board member, so that they can coordinate the day-to-day details that are associated with making the repairs. So the legislature is not trying to freeze an association's ability to perform work. They're trying to make sure that the decisions are made in an open fashion, but a decision about the day-to-day details is likely not what they intended. A decision on whether or not to rebuild a unit, I think, is intended to be within that discretion, but it will depend on whether or not you have an emergency criteria under the way that they are defining it. And the emergency is defined in RCW 6490-502. It defines it as imminent threat to health and safety, habitability, economic loss. I'll offer that we do in our restatements provide more of a definition for what an emergency might mean, because we want to make sure that we are providing our boards with more flexibility when there is an actual event like a pipe break or a fire. So anything you want to add, Jennifer?
I think you've covered it. So our next question is, please describe the process for having a homeowner and board member notarize a hold harmless agreement, recording said agreement, and how the recorded copy is received by the homeowner and association. Do both parties have to have it notarized at the same time and or by the same notary? If there's a cost to the association, can that cost be passed to the homeowner? So A hold harmless agreement is an agreement between the association and an owner to allow the owner to do some work, make a modification, what have you, that typically requires board approval and or touches the common or limited common elements. So with a hold harmless agreement, the board allows the owner to make their desired modification on condition that they sign and record this agreement, which binds the present and any future owner to their responsibility for the installation, use, maintenance, repair, replacement of that component, as well as any damage arising from the installation, use, maintenance, repair, replacement of that component. So the short answer is this is a little too specific, but how the hold harmless is signed really doesn't matter. It can be signed in counterparts, which means the board signs their part, the owner signs their part, they have different notaries. If the hold harmless was drafted by our office, both parties can send their parts to our office. We will have it recorded. The recording cost is put on the association's invoice for the next month. How that invoice is paid is up to the association. So typically we recommend that the cost is then assessed to the individual owner, because it's a cost that the association would not have but for this owner's request to make a modification. So the agreement has to be sent to the county recorder in whatever county the property resides in. So the board can compile, the association manager can compile, it really doesn't matter. It just needs to, before the work begins on the modification, the agreement should be recorded. That way, there's no question that this was the intent and it was done. We have had associations try to manage these documents in their own offices and by their employees. And we generally find that 10, 15 years down the road, the paperwork is lost. It was never recorded. So ensuring that this document is signed, notarized, and recorded is paramount. It has to happen or it's not effective. So the document is sent to the county recorder. It becomes public record. You can go onto the county recording website and pull up that document. Usually it shows up on the website, I would say 5 to 10 days after it's sent in. It could take longer. It really just depends. Once the title company will be able to pull it as well. And then the county will mail the original back to whatever address is provided on the document. Ken, did you have anything to add to that?
Yeah, I'll back up a little bit. The hold harmless is an agreement between the association and one owner that may go contrary to the general sweeping language of the original document. So we frequently see these for things like electric vehicle chargers or for heat pumps or a skylight that someone wants to put in. So if the general document says that the association is responsible for all heating equipment, then your goal here is that the owner wants to put in a heat pump that the association would, by the original terms of the document, be required to maintain. And so the association will just say no because they don't want that cost. So you are recording an agreement between the owner and the association to clarify an exception or to the general language. And that's why it needs to be recorded against the unit, not generally with the association. And it is so future owners of the unit know that they are getting the benefit and obligations tied to the piece of equipment that was requested. But that's all I've got to add. Question 4, can we send out notices of delinquency, email, mail, I assume by both email and mail, on the second day of every month to anyone that has not paid to get ahead of the new process on notice that has been given, even if it's not needed? So I'm assuming this is saying, well, look, if someone hasn't paid by the second it's technically late, even though we may not assess a late fee for another 10 or 15 days. And so we can just have our computer automatically generate late notices. And, I would suggest that we'd probably recommend against doing this, partly because if you're sending the notice before an actual penalty is going to be assessed, like the late fee, that seems inconsistent to us. And we'd also be concerned about the confusion that's going to be generated if people are having their bank send a check on the 1st and it doesn't arrive till the 5th. It's not really going to be late yet. So we think it's likely to cause more problems than it would solve. It's also going to really depend on the specific language of your collections policy or your CC&Rs or declaration about what constitutes a late payment. We have noticed that most declarations don't actually define what a delinquency is. And so that's something we've started to do in our documents that we do, is because it's easy to say when a payment is due, but then most associations provide a grace period before a late notice or a late fee would be assessed. And so we think that you'd probably have to go through and look at the individual association's documents, look at the collections policy, look at the administrative burden, and then also look at what the cost might be if the management company is going to be mailing out notices, which don't end up being necessary 3 or 4 days later. Anything you want to add, Jennifer?
No, I think you've covered it. So our next question is, there is a loss due to flat roof drains and negligence, and a slow leak occurs into 2 units. Must these 2 owners file a claim with their insurance? Would they be responsible for paying the association's deductible, even though the association is responsible and the association's insurance denied the claim? So this question is too specific and depends on too many different factors for us to answer here. The answer, who is responsible to pay for what, depends entirely on what's in your declaration. So most owners and boards look at responsibility for maintenance, trying to determine who's responsible to pay for what. That's not the case for damage. Maintenance and damage are completely separate analyses. So when there is damage, the answer is in the damage provisions of your declaration, and typically also partly in the insurance provisions of the declaration. The 2 are generally right next to each other. So when it comes to negligence, alleging negligence doesn't work, because you're going to have to prove that someone was negligent for that particular cost to be either assessed. Well, you can try to assess it, but collecting it is the problem. So just saying someone is negligent doesn't necessarily mean that they were. You have to have some basis for that allegation, and that basis should be able to be proven in court. So the courts recently have interpreted the exculpatory clause, which is the indemnification clauses in the declarations, to relieve the association of liability for leaks, even if the board was negligent. And if you look at it's Pike Place something, I can't remember off the top of my head, I'm sorry. So whether there's negligence or not on the part of the association likely doesn't matter, but negligence isn't the only thing that you should be looking at. If you have insurance shifting, deductible shifting language, the owner of the damaged property has to have insurance and is primary under the association's deductible. But that language must be contained in the declaration or declaration amendment to be effective. So in a nutshell, you insure property that you own. So it's reasonable for the unit owner's policy to cover damage to the unit. Damage to the roof would probably be a common expense. But all of this depends on the language in your documents because the language can change that responsibility. Ken, did you have anything to add to that?
Yeah, so the case which Jennifer is referring to is Pike and Virginia number 8 versus Pike and Virginia, a condominium association. So there is a very common provision in condo declarations, which was included in most declarations written by Pete Middlebrooks and Gary Ackerman, which basically said that the association is not liable for damage from water that leaks or flows from outside the building or from any of its pipes, except as covered by insurance. So if there's no insurance coverage, this would relieve the association of liability. And the appellate court decision from July of 2023 basically said that the paragraph was fully enforceable and included negligence on the part of the board. So you could not get around this by claiming that the association was negligent. And that's part of what Jennifer was trying to say, is that just because you say someone was negligent does not shift the obligations related to the interior damage to the unit. Jennifer's also right that some condos, the obligation to restore the interior falls on the association, and on some they fall to the individual unit owners. It just depends on the language of your document. And so you need to research each case specifically, and whether it's a roof leak or a pipe leak is likely not going to matter. Whether it's a slow leak or a sudden leak will make a difference for insurance coverage, but may not make a difference for the obligation to maintain. Anything else you want to add, Jennifer?
If you have a question regarding responsibility for damage, contact your association attorney. This is a really specific and precise analysis, and you don't want to make the wrong decision or try to assess something that you shouldn't, because then 6-8 months down the road, even longer, your collections attorney will tell you we can't collect this, there's no authority for this under the governing documents. And that happens routinely in our office. So if you have a question on whether or not you can assess something, or whether or not damage is the responsibility of an owner, send it to your association attorney for the actual correct answer.
So the next question: what if the issues to be discussed in executive session don't result in any kind of decisions that require an action? Okay, i.e. to discuss issues with personnel or management company. So I'm not sure what the i.e. means, but if you have a board go into an executive session and there is no decision to be made, they just come out of executive session and move on with their meeting. You don't take a vote to make no decision because you're not making a decision. You do need to make sure before you go into the executive session that you have properly made a motion and stated what the purpose of the executive session is. But you could have an executive session with the purpose of discussing a roofing contract and come out of the discussion with no action to enter into a roofing contract. So the motion would still remain to go into executive session stating what the discussion would be about. You just would not have any kind of an action or motion after the executive session where the board is taking and making a decision. Anything you want to add, Jennifer?
No, I think you've covered it. So the next question is, Ken has mentioned that a vendor's employees who are covered by L&I workers' compensation insurance cannot sue their employer in the case of an injury on a work site for a condominium, but they can sue the association. What are some examples of how this could happen, and what can the board do to protect the association from a claim like this? So a couple examples are landscaping employee is on a ladder trimming a tree or a bush or what have you and falls and gets injured. or some vendor employee is walking along a sidewalk and trips on an elevated piece of the concrete and is injured. Another example is an employee of a vendor gets into a car accident on association property. So in general, there's no way for any association to completely guard against all potential claims. There's just no way that can happen. It's physically impossible. So ways to help the association prevent successful claims: having legal review your contracts, making sure that there's an indemnification provision in the contract so the employer must defend and indemnify the association for claims arising under their work, and cannot use workman's comp as a limit on that duty to indemnify. Please note that some vendors have specific exclusions in their insurance regarding multifamily housing or condominiums. And that would be a complete bar to the association having coverage under their insurance for a claim of this sort. So getting your contracts reviewed is extremely important. Be an additional insured under the contractor's insurance policy. And again, it really depends on the whether that particular exclusion is in the insurance or not. Confirm the contractors have workman's comp insurance that's current. You can find that on the state L&I website. You can also double check with your general liability insurance to ensure that that's up to date and vendor contracts are covered under your particular liability insurance as well. Ken, did you have anything to add to that?
No, I think you've covered it. Next question. We're aware that WUCIOA will be coming into effect soon and are considering whether or not we should amend our association bylaws and declarations beforehand. Would there be any strategic or legal reasons to amend our governing documents before the new laws take effect? We're thinking about having an attorney map out how our current documents align or conflict with the updated RCW as in only. So there is a lot of confusion and a lot of news about the new statute right now. So one reason you might want to consider doing it now is that you're more likely to get participation amongst the members to actually approve the documents. And that is a challenge even, when you've got nothing going on, but it's difficult to get owners to vote on anything. And so right now there's a lot of stuff in the news about the changes in the statutes, so you may have better participation. We do think it is helpful to have documents that don't conflict with the statute. So if your documents say you have to give 10 to 60 days notice, but the statute says 14 to 50 days, you end up with less arguments with owners about whether or not you've provided the proper number of days notice if you have amended your documents. So we do think that it is helpful to have the documents amended before they go into effect in January. This is probably more important for the bylaws, which is where most of the requirements for meetings, notice, and voting go. And it may depend on how your documents are written. If you wanted to have your notice provisions reflect the current statute, that probably requires an amendment to the CC&Rs or declaration as well. So there's not an obligation to update them. There is an obligation to comply with the statutory requirements. And we have worked with some clients where we just took their existing bylaws and declaration and essentially redlined them so that the client could understand which portions they could not enforce and what new requirements they had to put into their document. And if that's a workable solution for your community, then that works just fine. There is also an ability, once WUCIOA takes effect, but that means not until 2028, that you can, as a board alone, change conflicts within your document. So you can notify all the owners of your intent to change it, and then it takes a 2/3 vote of the board. And if you've done the notice and the 2/3 vote, you can record an amended declaration to eliminate the conflicts between your documents and WUCIOA. You can't do any of the voluntary things that are under WUCIOA, but you can eliminate the conflicts. And for some communities, that may be a reasonable thing to do. Anything you want to add, Jennifer?
I think you've covered it. So we're down to our last two questions, and it's 10:36. If you have questions, please feel free to put them in the chat, and we should be able to get to a few. So our next question is, if a homeowner removes a common fire safety related element, how is due process handled when the association had to replace that element immediately and could not wait for the due process meeting to happen first? So this is probably covered in your rules or governing documents, but often an emergency that threatens life or safety must be remedied first before a compliance hearing happens. So if you have a particular requirement that owner receives notice as expeditiously as possible before the association can enter, that's usually different for an emergency. So say someone tried to remove a horn for the fire system or damaged it and you had to go in and replace it. That the entry and replacement doesn't necessarily require due process because it is a life safety issue. The assessing the cost of that particular replacement, if that is allowed under your governing documents, does require due process. So an emergency would justify immediate repair by the association. Due process can be conducted after the fact regarding assessment of the cost to the owner. And due process is informing the owner of their notice and opportunity to be heard, giving them notice of the violation. If you're enforcing rules, opportunity to be heard before a fine is levied under WUCIOA and is general good practice. Offering notice and opportunity to be heard before assessing a particular cost to an owner when it comes to misconduct or repairs to common elements, if that's allowed under your governing documents. And then the cost that can be assessed must be reasonable under the circumstances. So if you have questions about whether a cost is reasonable, contact your association attorney. They can definitely help you answer that question. Ken, did you have anything to add?
Yeah, the focus is you have to provide an opportunity to be heard before expenses can be assessed to a unit. Now, this is true in WUCIOA for almost any kind of expense that you want to assess to an owner. The ones which don't require an opportunity to be heard are late fees for delinquent assessments. But if you want to assess the cost under the insurance deductible, costs for misconduct, cost for expenses that only benefit one unit, those all require notice and an opportunity to be heard before the cost can be assessed against the unit. And this is a big change for a lot of communities that have adopted insurance language because they're used to just going ahead and assessing a bill for the repairs to a unit without any notice to the owner in advance. Or they will just automatically assess the deductible to the owner without any due process. And That's one of the things which WUCIOA is very clearly requiring now, is that you have due process before that assessment can be made. All right. Last question we had in advance is, what is the board's obligation to intervene when faced with a homeowner who continues to threaten a neighbor? Okay. So the short answer is we have covered this previously in other sessions or other Zoom sessions. But the short answer is that the association is not the police, the association is not the courts, and the association doesn't have the rights that the individual who is being threatened has. So the short answer is that the board can report behavior to the police, but that's not a substitute for the threatened owner reporting it to the police. The owner has legal rights the association doesn't have, meaning the owner can go to court and get an anti-harassment order or a no contact order. The association doesn't have that authority. The board can sometimes suggest ways of using alternate dispute resolution to try and reduce the tension between neighbors. May or may not be successful, and Jennifer's already mentioned, I think today, about the mediation program that WSCAI offers. Okay. The one caution which we have is that there has been an opinion issued by the Department of Housing and Urban Development that a board is required to exercise what little authority it does have to stop harassment against a protected class. So if a person was being threatened because they are a protected class based on race, religion, sexual orientation, etc., then the HUD's opinion was that the board had to investigate and determine if there was a violation of the governing documents. And if there was, the board had to take action, like write a letter, a warning letter to the owner, or a violation notice to the owner. So as a result of that particular HUD decision, a lot of attorneys across the country started recommending that associations adopt anti-harassment policies as part of their rules, so that there would be an ability to fine an owner in violation if they were continuing to threaten or harass one of their neighbors. Okay. But it isn't necessary that the board conduct an investigation to determine that there actually is a violation of the harassment policy. You can't generally take one owner's word against another and consider that to be an adequate inquiry with use of objective information. You would need more than just one person saying their neighbor did something. And it is a challenge because the court systems and the police also don't know how to deal with people who are making threats which are not so blatant or believable that they warrant intervention. And so we see owners wanting their boards to intervene when the police and the courts will not. And we generally would advise that you seek out some legal advice, because we don't want you intervening and taking on or creating duties which you do not have to individual owners. Now, I guess my best example is some years ago where a board was trying to protect an owner from a violent ex-boyfriend who kept showing up at the property, and they wanted to know what they could do. And the answer really was there was nothing they could do. That the individual owner had some rights that they could pursue, but the association didn't really have jurisdiction over a non-resident in any way. And other than to keep a watchful eye out and call the police if they thought this threat was appearing, there was not anything the board could do. The board could not guarantee safety of its residents. So, anything you want to add, Jennifer?
Just in general and briefly, the only authority the association has is to find violations and potentially levy fines to residents or individuals who are governed by the association's governing documents. If you have what used to be termed a neighbor-to-neighbor dispute, all the association can do is send a warning notice and potentially levy a fine. If the individual who is making the harassment or is committing the harassment continues, there's really nothing the association can do. This is one of the times when an individual owner has more authority than the association to deal with a problem. And typically owners want someone else to deal with it because they don't want to take the time or energy or have their name on a police report. That just doesn't work for this particular circumstance. So Chelsea, do we have questions in the chat?
All right, so first one, after a hearing with the board has been completed, what portion of the hearing are available to the parties? Should details of executive session on how assessed payments were decided upon?
Well, I'll volunteer that anything done in executive session is a record which would be withheld. So I'm not exactly sure what the question is related to. If the board has made a decision following an executive session regarding how payments are to be made or collections are to be done, that could be reflected in the open meeting minutes. In terms of the, I'll say there's some question about what would be protected and what would not be protected related to a dispute between two owners, because there's one part of the statute that says that records that have been relied upon by the board in making a decision should be available to owners who ask for them. But then another section of the statute which says that records which would somehow interfere with the privacy of an individual should be protected. And so it's going to start to become very fact specific on whether or not records should be released. And you may need an attorney to give you some advice. Jennifer, your thoughts?
The hearing itself should not be an executive session. So if there were minutes taken at that hearing, those minutes probably should be available to the individual parties to review. The board's determination should be a record of the association and available for the parties to review. But anything held in executive session, the discussion, what have you, that's exempt. So your mileage may vary. This is not legal advice. If you have specific questions, contact an attorney. Next question, Chelsea.
On Ken's comment to revise, 2/3 vote of the board or the members question mark.
So if this is in regards to conflicts between your documents and WUCIOA's requirements, the answer is 2/3 of the board alone. You do not need a member vote to resolve conflicts with the statute.
I would point out that this is just for WUCIOA communities now, and then after January 1st of 2028. So any declaration amendment now, if you're not a WUCIOA community, still requires ownership vote. But there is an exemption that the legislature put under WUCIOA to allow boards to remove language that directly conflicts with the statute. So if the provision that you're wanting says, as provided by the declaration, you can't amend that by board alone. It must be ownership vote. If you have questions, contact your association attorney. This is not an area where mistakes are easy to fix.
All right, should we require unit owners who have private events in the clubhouse name the association as an additional insured?
I'm going to say that'll depend on the kind of event that you're having. There are companies which sell post liquor insurance, where if you're allowing alcohol use in your clubhouse, that you can require the individual owner to buy insurance, and we would suggest, yes, absolutely, the association should be named as an additional insured on those policies. If you have, I guess if you were letting an owner use the cabana for business purposes, I'd probably want to make sure that the association was also insured under those circumstances. But I'd have to have more specifics to give legal advice, both about the kind of facility you have and the kind of activities being done. Jennifer?
I think you covered that one. So Chelsea, let's do the shorter ones. And I know there's a much longer question, but that longer question, it requires legal advice. We're not going to be able to cover it.
There's a couple longer questions. Could you message me to let me know which one?
Yeah.
Okay. So shorter question, if no one is willing to get on the board and there are only one board member left out of 6 positions, what is the first step for receivership?
Well, we get this a lot. The only step for receivership is you need a lawsuit, and a court is the only one who can appoint a receiver. So if you want a receivership, that means you have to file a lawsuit and sue every member of the community. And it's going to be an expensive process.
You ready for the next one?
Sure.
Oh, sorry. I was just going to add, receivership is actually extremely rare. I think Ken has said before he's only seen it once or twice.
I've had one, and it was because a bank owned several of the units, and the bank had a foreclosure proceeding, and that was why a court was able to appoint a receiver. A bankruptcy court could appoint a receiver too, but you're not going to end up with your association going bankrupt in order to get that to happen.
All right, I think, oh, if there were not sufficient funds in operating account number 1 from which reserves draw, although sufficient funds were available in a separate operating account, does the association have to pay those 2 months' reserves back to reserves?
Well, I'm going to not understand that question, but I'll offer a couple things about reserve contributions. A failure to fund the reserve contribution is not the same as using reserve funds to pay for an expense. So we have advised clients before, if they're running out of money in their operating account, just stop making the reserve contributions. Those are budgeted projections. They are not actually reserve contributions until they are made. And if you don't have adequate funds because of other unexpected expenses, then you just don't make all of the reserve contributions you had planned. Telling me you have 2 different operating accounts starts to not make sense to me, because I don't understand your accounting, and I don't understand why you could pay for reserves from one and not from the other. If you have an expense that requires you actually to write a check out of your reserve account into your operating account, then I think it qualifies for the notice to all the owners and a plan to repay it. unless it would create an unreasonable hardship on your members. Anything you can think of, Jennifer?
I think you've pretty much covered it. So unless someone has another question, we're at 10:55.
Yeah, I think we can leave early.
All right. Thank you, everyone.
Have a good day.